Here's our agenda, and as Daniel just characterized it to me, it's like a bunch of small plates, perhaps 5-minute mini webinars, given the range of topics we'll cover. And the topic this morning does sweep in an array of federal issues in the natural resource space, which amount to more than a few of my favorite things. 2022 could be a busy year, although the midterms may also diminish the administration's appetite for controversial actions like a second round of rulemaking under the National Environmental Policy Act. So here are some of the topics that may be seeing change in 2022. I'm particularly intrigued by potential new uses of public lands, which really don't come along often. So Daniel, can we advance to the next slide, please? So turning to that potential new use of public lands, first I'll hand it off to Daniel.
Sure, and thanks, Anne, and thank you all for being here with us this morning. I want to talk a little bit about permanent carbon sequestration in the offshore context. One of the things that happened last year, and I know Anne and I were kind of surprised by it, is that the recent Infrastructure Investments and Jobs Act subtly amended the Outer Continental Shelf Lands Act to provide some needed clarification for what offshore carbon capture and sequestration would look like. If before that amendment you had gone into the statutes and gone into the regulations to look at, whether offshore facilities could be used to capture and permanently sequester carbon, it was kind of ambiguous. The Ocean Dumping Act has a broad prohibition on a variety of kinds of disposal activities offshore. And so if you looked at this pre-amendment, you would have wondered, and there was really a need for clarity about offshore CCS. So that Jobs Act amended OXLA and the Ocean Dumping Act in a couple of important ways. The first thing that Congress tasked BOEM to do was to undertake a rulemaking effort to begin establishing a framework for offshore CCS. And there's really no framework for it right now, and we haven't seen anything proposed by BOEM just yet as far as what that framework would look like. Obviously, there will be a permitting component and certain standards for that. A number of federal agencies have actually studied offshore CCS before, but this is going to be the first time that we actually see a framework being established. Now, the Infrastructure Act also expects the agency to do that in 1 year. We'll see what happens. We haven't seen anything on the unified agenda yet. So we don't know exactly what it's going to look like. But one of the things that we will know is a key feature of the OXLA amendment and the Ocean Dumping Act amendments is that we have a new defined term in carbon dioxide stream. That stream basically means all captured carbon dioxide and any other sort of incidental associated substances that come from the use of carbon capture technology, basically substances that are intermingled with the pure carbon dioxide itself. The Ocean Dumping Act was specifically revised to exclude carbon dioxide streams from the prohibition of the Ocean Dumping Act as long as that stream is permanently sequestered. So we're going to be watching that. Maybe we will see something in 2022. Certainly we'll expect to see something if the agency is going to hit its 1-year deadline. But I'm going to pass it back to Anne to talk about what that's going to look like on shore.
Thanks, Daniel. And that amendment to OXLA certainly did bring some needed clarity, because I think there was a lot of perhaps confusion amongst some people as to whether prior to the amendment OXLA would have allowed permanent offshore carbon sequestration. Some folks had opined that it would, but I think now we have the clarity that was required, and it will be certainly interesting to watch that move forward as a potential new offshore industry develops. And then to onshore public lands managed by the Bureau of Land Management, the circumstance there is different. As folks probably know, public lands are managed holistically under FLPMA. FLPMA is a little more accommodating than OXLA. And back in the Obama administration, the Bureau of Land Management actually issued guidance on exploration and site characterization activities related to potential permanent carbon sequestration on public lands. To my knowledge, it was never used, but the discussion is very active again at the department, and I believe there's a fair bit of interest in opportunities for carbon sequestration on public lands. The agency is now working on guidance or a policy document of some sort. Even though FLPMA is certainly not crystal clear on this subject, I expect that it's more likely than not that the agency will find a way to accommodate it under the statute. There'll be lots of things, of course, that need to be nailed down in the draft guidance, like what kind of property interest might they convey? Would it be a right-of-way, a lease of the type we see in the oil and gas leasing? Would it be conveyance of a fee interest, perhaps? And how would that relate to the department's obligation to protect its multiple use mandate? What might bonding requirements look like? So I think the agency is certainly studying a lot of the issues and may actually be somewhat close to draft guidance, even though I don't expect its release to be imminent. I also wanted to mention here that the Council on Environmental Quality has drafted guidance intended to provide recommendation for efficient implementation of existing environmental review requirements around permanent carbon sequestration. That guidance was required by some legislation that was passed in 2020, and it builds on a CEQ 2021 report to Congress. Now, that report to Congress, it basically has a survey of all the potential federal reviews and permissions that might be needed related to permanent carbon sequestration, whether it's on public lands, offshore, private lands, or state lands. But it doesn't really provide any insight into how a federal review process would work if it involves federal permissions and agencies. So they are working on guidance to that effect, which I think will be really key, given the complex requirements under the EPA or state permitting scheme and how it would flange up with needing to get federal property interests or other federal permits. The guidance is at OMB for review. I don't know a timeline for when it may come out, but that's something to watch for. Daniel, on to the next slide.
Thanks, Ann. I want to talk briefly about this administration's goals for developing renewable energy projects on federal public lands. The Energy Act of 2020, which is part of the 2021 Consolidated Appropriations Act, which was actually signed by the Trump administration in December of 2020. That act established a goal of a minimum production of 25 gigawatts of power from renewable sources on federal public lands. And if you need some context for 25 gigawatts of renewable sources, that sometimes that doesn't mean anything to me. That's about 25% of our existing solar generation nationwide. So it's a pretty significant development goal. In January of this year, because standing up 25 gigawatts of renewable energy sources and getting that energy to places where that energy is demanded, and coming from the West, the agencies had to enter into a memorandum of understanding that is aiming at improving public land renewable energy project permitting and coordination. And it aims to streamline the various permitting, environmental, and cultural reviews that are required to stand up these new generation facilities on public lands. And by the way, because those lands are remote, there's going to need to be a lot of new infrastructure created to get that power to where it needs to be. if you look at the list of signatories on this memorandum of understanding, it's almost every federal agency that is involved in environmental reviews or cultural reviews. The U.S. Departments of Interior, Agriculture, Defense, and Energy, and the EPA, including many services and bureaus and other subordinates, have all signed on to this. And what they're going to aim to do is to establish renewable energy coordination offices all across the Bureau of Land Management. And those will be populated by specialists from a variety of agencies that will assist in speeding these reviews along and accelerating them, and also making sure that they comply with NEPA, the NHPA, and other review statutes. And I'll come back to this these new renewable energy developments on public lands in this administration's goal. But for right now, I'm going to send it to Anne to talk about some oil and gas developments.
Thanks, Daniel. And just to wrap up the discussion of renewable energy, it's going to be interesting to see if any of these coordination efforts and efforts to expedite reviews will create positive benefits for the private sector. It'll certainly be worth the time to invest to try to figure out how to leverage those new opportunities that have been created by some of these efforts to make projects go faster. I hate to sound cynical, but obviously the same type of efforts has been made across administrations for decades with respect to different sectors and targets of needed efficiency, perhaps with mixed success. So while I know the administration's commitment is sincere, I think it'll be, certainly in part up to the private sector to figure out how to really take advantage of these new opportunities and leverage efficiencies. So I apologize for the sun here, which is lovely in my office, but is also hitting me in my face right now. So turning to oil and gas development, the more traditional and longstanding use of public lands, as folks probably know, on the leasing front, the administration committed to pause oil and gas leasing pending a programmatic review. That leasing pause was enjoined by the district court in Louisiana, which ordered the administration to move forward with sales. That district court decision is now at the Fifth Circuit. And I'm certainly eagerly anticipating that decision to see what the Fifth Circuit thinks as is the scope of the agency's discretion under both OXLA and FLPMA. And those could be two different answers under two very different statutes. So after the district court ordered the administration to move forward with lease sales, the administration held its first sale offshore. And that lease sale has now been vacated by the district court in DC on January 27th, 2022. The district court issued its decision. It was based on an underlying NEPA analysis conducted in the last administration. The district court's opinion vacating the leases has gotten a lot of press, and I think there are different ways to consider that opinion. One could consider it perhaps very narrowly as kind of a narrow fact-specific process opinion based on an agency's failure to address an internal inconsistency that the district court found had been brought to BOEM's attention by more than one court. One might also consider the opinion as yet a step farther in broadening an agency's obligation to consider impacts, in this case, impacts of the lease sale decision on foreign consumption. So where that ends up will be interesting to see. I expect the administration is not displeased with the decision and will be doing corrective NEPA work as opposed to appealing. We've also seen a recent fairly high-profile lease cancellation in the hard rock minerals category with Twin Metals. I don't know if that foretells any cancellations of oil and gas leases, but it's, a potential tool in the agency's toolbox in extreme situations and probably very fact-specific situations. Also, with respect to oil and gas leasing, the BLM has issued guidance for how to deal with environmental assessments that are in litigation or back at the agency on remand, including increased headquarters oversight. And in fact, the Biden administration has managed to get all or nearly all litigation over Trump administration oil and gas leases stayed or dismissed. And to the extent those leasing EAs have been remanded, none of them have yet been reissued. So it will be interesting to keep track of that to see what the Biden Department of the Interior does with leasing EAs that it reissues. Of course, there was a long-awaited review of the oil and gas program, which had been promised for many months. To me, it seemed to fall with a bit of a thud. It was issued the day after Thanksgiving by the Department of the Interior, and without the type of assessment that some expected related to climate. None of the recommendations were really a surprise. It, related a lot to the fiscal implications of oil and gas leasing, and the desire to minimize speculative leasing and non-competitive leasing. I expect that the agency will move a number of those recommendations forward in 2022 to include a royalty increase on new leases, which we've already seen forecast when the BLM accidentally posted its lease sale notice for an upcoming onshore lease sale. Another thing of interest, a proposed rule from the Department of the Interior on venting and flaring for federal oil and gas leases may be fairly imminent. It's at OMB for review, and it's characterized as reducing methane emissions in the oil and gas sector and addressing mitigation for impacts of climate change. Of course, the same type of rule was promulgated in the Obama administration and was not successful given various court challenges. So it'll be interesting to see this year how the agency deals with what will be court challenges. Daniel, on to the next slide.
Thanks, Ann. And I want to talk briefly about the Endangered Species Act. As many of you are familiar, the Trump administration made some significant regulatory reforms to the ESA in terms of critical habitat designation policies, in terms of interagency review processes and so forth. And a number of those reforms have been identified by the current administration as suspect. They are intending to review a number of those rulemakings, and we're already seeing movement towards that rescission process. One of the rules that we have right now that's been proposed by the Fish and Wildlife Service relates to the prior administration's critical habitat rulemaking. That rulemaking involved different principles for making determinations about critical habitat and what the agencies were to review when they designated critical habitat. Under the Trump era revision to the critical habitat rule, the agencies were supposed to consider economic impacts and other types of impacts, national security impacts, when they were evaluating whether to identify critical habitat for a listed species. It was also, that rule also instructed the agencies to consider proposed exclusions from critical habitat if those exclusions were requested by different entities. This administration has proposed to recede that rule, to take it back, to rescind it. And if I had to kind of summarize the contents of that rule, I would see it as a moving back towards the agency taking a posture that critical habitat should be designated wherever it's essential for a species to recover. Obviously, the Endangered Species Act aims at the recovery of listed species and eventually taking them off the list, not because they're extinct, but because they have successfully recovered. And more narrow approaches to critical habitat focus on critical habitat where a species occupies it. So I think we are going to see a shift back towards designating critical habitat where agencies believe that it's essential to designate critical habitat to foster species recovery. We've also seen a new memorandum just this January between the Army Civil Works and NOAA for Section 7 consultation that relates to existing structures and whether those structures are included in the analytical baseline for various projects. And that's worth exploring because especially as we're talking a little bit about offshore carbon sequestration. This new guidance will have most immediate impact in the Pacific Northwest with salmon fisheries, and that's sort of what it was designed for. But I would familiarize yourself with it if you have any kind of terminal facility or new construction planned where there's an existing civil works project and there's also endangered species considerations. And then one of the things that I think is, Anne, were you about to say something?
I'm particularly interested in this memorandum between the Army and NOAA. And so I just wanted to say another thing about it. I think this memorandum is an attempt to address NOAA's longstanding concerns about consultation with the Corps in the context of the regulatory program. And its conclusions really do apply to the regulatory program. So, and the memorandum also may seem to be contradictory of the current regulations on how to define environmental baseline, which I'm confident NOAA was not pleased with when it was promulgated in the last administration. So in Section 7, consultations related to Corps of Engineers permitting, if you have an existing structure that you're modifying, renovating, the future effects of the existing structure is not always just going to be part of the baseline. So the agencies are going to look at whether the action the Corps is being asked to permit will actually kind of prolong or change the life of the structure into the future. So if it would, the impacts of the structure get attributed to your current action, which would then allow NOAA to include reasonable and prudent measures or reasonable and prudent alternatives that are broader in scope and have a greater impact to project proponents. So it's potentially meaningful in individual circumstances. So far, we haven't seen anything from Fish and Wildlife as to whether they want to take this same approach, but we should certainly watch that space. Daniel, back to you.
One of the things I wanted to mention as well is that there are a number of new listings for plants and animals that are endangered or threatened on the unified agenda. There's always a long list of listing actions from the Fish and Wildlife Service, and it can sometimes turn into white noise. But one of the things I was realizing about these new listing decisions is that, they expand the footprint of the Endangered Species Act, right? If there's a species that was not endangered, at least designated by the service as such, and then it eventually is, obviously the ESA applies in a new part of the country in a new kind of habitat. And I chose this picture because I think it kind of highlights one of the tensions that I'm seeing in the environmental NGO community. This is the Teams buckwheat. It's a small flowering plant. It's about 16 inches tall, 16 inches wide, and it grows only in the Silver Peak mountain range. And it has recently been listed as an endangered plant species. And then just last week, the Fish and Wildlife Service proposed to designate its entire range, which is about 900 acres, as critical habitat. Well, you may be thinking that's not a particularly interesting looking flower, Daniel, and why are we talking about this endangered species? Well, this buckwheat sits on top of one of the few lithium deposits in the country. And if we're talking about energy transition and advancing this administration's energy transition goals in terms of renewable development, obviously we're also thinking about battery storage in that context, and that means we're thinking about lithium. So I think we're going to see a fracture, and we're already starting to see the cracks of it, and I think we will continue to see those cracks widen into real fissures in the NGO community. And it may come down to NGOs prioritizing biodiversity concerns over climate concerns, and those individuals, those entities, those NGOs may end up throwing a wrench into this administration's renewable development goals for public lands. I think that's going to be really interesting to watch. I'm just excited to see what happens there, because I think some of the case precedents may end up having positive benefits for more traditional forms of energy. We've also seen, before I pass it back to Anne, some developments under the Migratory Bird Treaty Act, which involves codifying the prohibition on incidental take. Anne and I have talked about that before, and if you'd like to talk about it with us further, do please reach out, but I'll send it to Anne to close us out.
So in our final minute and a half, and if you do have any questions, please feel free to follow up with either of us. In our final minute and a half, I'll just mention my longtime favorites, NEPA and the Clean Water Act. I think, as folks probably know, we're awaiting a final stage 1 NEPA rule that addressed some relatively narrow changes to the Trump administration rule. I expect we will see that relatively soon this year. And then in terms of waters of the US, of course, EPA and Army are engaged in another rulemaking defining waters of the US. The comment period closed just a couple of days ago. I do expect that we will see that rule come out this year before the Supreme Court hears and decides Sackett versus EPA, which is pending at the Supreme Court as to the scope of the Clean Water Act. So depending on how that decision comes out, of course, that could then occasion more implementation and rulemaking changes at EPA and Army. EPA has said it wants to do a phase 2 waters of the US rulemaking. I'm more inclined to think that may be on hold now because of Sackett, especially given the probability that they would like to go broader than the Rapanos significant nexus decision. So here we are at 10 a.m. and I'm really pleased that you could join us this morning. Our next webinar will be in March, and I hope that you can join us then as well. Thanks very much.
Thank you all.